Good morning. This is a day of great elation for all of us today. We're excited about the future for the children and parents and their families in the Kern High School District. This has been a very, very long journey, and you're going to hear about a lot of pieces of the puzzle, but we're happy, so happy beyond belief today. Our first speaker is our lead counsel, co-lead counsel, the fierce and fabulous Cynthia Rice of CRLA.
Good morning, and thank you all for coming. As Eva said, this is a really exciting and wonderful day. It's also a challenging day for us. It's about moving forward from a place that we've been for really the last decade. I'm with California Rural Legal Assistance, who has an office here in Delano and has been in Kern County for our entire 50+ years representing low-income families. It is my privilege and our privilege to represent Latino and African American students and parents of students who are the plaintiffs in this lawsuit that we are about to tell you about today. This lawsuit is unique in many respects, both in how it began and how it is going to be resolved. Really, the story goes back to a report issued by the U.S. Department of Education Office of Civil Rights, analyzing 2010 expulsion and suspension data nationwide. Interesting about that data was that Kern County was a standout, not only for the Kern County, Kern High School District was a standout, not only for Kern County, but for the state of California and nationally as having one of the most notorious set of statistics around expulsions and suspensions, and particularly troublesome and problematic when it came to the analysis of expulsions and suspensions of African American and Latino children. CRLA, along with community organizations and parents, were able to use this data to engage the district beginning right on the heels of the reporting of that data. Reporters like you actually did in-depth pieces that revealed that the suspension and expulsion practices have been pushing Latinos and African Americans out of the general education setting and into continuation in community schools for years, and that there was no sign of that stopping. Unfortunately, Kern High School District's reaction to that data and that analysis was to defend their practices and deny the data. They defended their practices, taking the position that expulsions were necessary to get bad kids out of school so that good kids could continue to learn, and they denied the data, saying that no, we weren't any different than any other school district. We just reported the information. That wasn't good enough for the parents and community organizations in Kern County, and they began to engage Kern High School District. The Dolores Huerta Foundation, the National Brotherhood Association, Faith in Action Kern County, all came together and demanded that the district deal with the numbers and the children that they represented by taking a comprehensive look at their discipline proceedings. Kern said no. The community members engaged at board meetings, they engaged one-on-one with administrative officials, and when the answer continued to be no, when the Kern High School District continued to deny and defend, they came to us. And we had the privilege of listening to their story, doing our own data analysis, Public Record Act requests, and determining that yes, there was something very wrong in the Kern High School District, and it was students who were Latinos and African Americans who were suffering from it. But after they retained us, they didn't run to the courthouse steps. They asked us to sit down with the district and put in front of them the data we had collected and offer to them solutions for addressing the disparities in discipline, for addressing the racially and ethnically hostile educational environment that their children were being subjected to. And we did that almost 3 years ago, in August of 2014. We sat across the table from the district, showed them our data, and said, what can we do to help? We made available to them grants and leads on how they could get funding for alternative discipline programs, training, policy development, etc. And what did the district do? They defended and denied. They continue to defend their practices, and they denied that the results of those practices, the disparities in expulsions and suspensions of Latinos and African Americans, had anything to do with implicit or explicit bias. We filed a lawsuit. We only filed a lawsuit as a last resort, and then for the next 3 years, at every turn, our clients, the parents, the students, and the community organizations that are here today said, let's figure out a way to fix this. We don't want to go to court. We don't want to stay in court if we don't have to. Let's figure out a way to fix it. 3 different occasions, we approached the district asking them to implement the kind of training, to do the kind of data collection, and retain the kind of experts that are all reflected in the settlement agreement we have today. And they defended their action, and they denied our request. Over the course of the 3 years, we had to defend ourselves. We defended from the district's persistent refusal to engage in change and instead to attack the lawsuit. We survived motion after motion while they paid based on their report on their website, paid out $700,000 plus to their lawyers to try and get this lawsuit kicked out, instead of spending that money to bring in nationally renowned experts whom we recommended to develop and re-establish a behavior system that's going to really address any behavioral problems in school, and to provide input and analysis of the results of that effort to the community. They denied it. They would rather fight, they did rather fight, and that's where the money went. Finally, on Monday, the district responded positively to a request for exactly the type of remedies that we have been seeking on behalf of our clients for the last 3 years. And as my colleagues will go into in more detail, these remedies can represent a sea change at Kern High School District. If they stop denying and defending and start embracing and implementing the elements of the settlement agreement, there will be a change for all students in Kern. The settlement agreement has a number of critically important factors. The 3 of them resonate from the very earliest meetings that we had with the district. Data. We want to know, parents want to know, what's going to happen to their kids when they enroll in Kern High School District. And they want to know it in real time. What has Kern High School District traditionally done with data? Again, back in 2010, they denied it. It wasn't true. In 2012, they were required to submit data to the California Department of Education about expulsions and suspensions, but they weren't able to certify that data. So that data was not available to the public. Parents couldn't tell what schools were doing to their kids in terms of expulsions and suspensions. Then in 2013, something very interesting happened. The district did report its data, and there was a remarkable reduction in the number of expulsions. But if you looked at the number of children who were pushed out of school, there was no significant decline. So what had happened? Kern High School District changed the reporting. Those students were no longer expelled. They were voluntarily or involuntarily transferred. But the numbers of kids who were pushed out of their classroom situation and into continuation or community high schools where they had no access to extracurricular activity, limited access to the courses they would need to get into UC system, and in many respects, not even access to courses that would allow them to graduate, and the prospect of being enrolled in schools that have the lowest graduation rates, the highest dropout rates, and the lowest academic achievement in the district. Nothing changed except the numbers and what they were called. So this settlement agreement changes that and requires that the district maintain data on expulsions, suspensions, transfers, both voluntary and involuntary, and that that data be reported at a community session twice a year to parents so that they know what's going on in the district and numbers can't be hidden anymore. Experts. The district has defended themselves for the last 3 years, saying that they hired experts and they were implementing plans. This settlement agreement brings into play 2 nationally renowned experts, Dr. Jeffrey Sprague, who I think we have his video in the back of the room, who has done more work on alternatives to discipline than pretty much anyone in the country, and Rachel Gosel in the Perception Institute, who brings the expertise of having dealt with districts around the country on the issue of racial bias and implicit bias in discipline and classroom management systems. These 2 experts will inform the overhaul of Kern High School District's discipline or behavior management matrix and training. Kern had taken the approach for training of providing a panoply of training opportunities to their teachers that they could take if they wanted to. And there were some nice trainings listed in those opportunities. None were mandatory, and none were part of a comprehensive, integrated approach to reforming the discipline system. This settlement agreement does that by requiring that every single teacher, every single administrator, and every single police and security personnel be trained over the course of the next 3 years in alternatives to discipline, implicit bias, social emotional learning, and a number of other issues that other people on the panel will speak about today. In a comprehensive way that's designed to address behavior management, discipline, if you will, comprehensively through a racial equity lens that will specifically address policies and practices that have a disparate impact on Latinos and African Americans. And transparency. The community meetings are going to be where many of the people who are in the audience today are going to have the opportunity to hear the district tell them what they've been doing and hold the district accountable for having done so or not done so. Twice a year, that data will be reviewed with the community, and the community will have an opportunity to ask questions and provide input. The settlement agreement also allows for remediation funds for the students who are the brave plaintiffs in this case, who need a help up to make up for the fact that they were denied opportunities for her. Altogether, there are a number of other very, very critical things that will allow Kern to move forward, to embrace the diverse population that it has in its schools and implement a plan that will make sure that those children are treated equally. This is a civil rights moment for Kern High School District, for Kern County. I'm proud to be part of it, and thank you all for coming.
Our next speaker is Kip Eustace from MALDEF, the Mexican American Legal Defense and Education Fund.
Good morning, my name is Kip Eustace, as my colleague Eva Patterson said, and I'm a staff attorney at MALDEF, one of the legal organizations representing the plaintiffs in this litigation. MALDEF is a national civil rights nonprofit with headquarters in Los Angeles. Our mission is to protect and to promote the civil rights of Latinos in the United States, particularly in the areas of employment, education, voting rights, and immigrants' rights. As my colleague Cynthia Rice has mentioned, at the heart of this litigation was a system of student discipline that drove Latino and African American students to dead-end alternative schools that offer few educational services and demand little engagement from students. Latino and African American students were pushed out of school in greater numbers than their peers. I would remind educators here in Kern and across California that a student's decision to transfer to an alternative school is intensely personal and must truly be voluntary. The practice of using alternative schools as repositories for students rather than helping students to thrive in their regular schools is an abdication of schools' constitutional obligations to provide a high-quality education to all on equal terms. Moreover, the achievement gaps engendered by disproportionate discipline and push-out of Latino and African American students are of particular consequence here in Kern and across California. Latinos comprise 65% of students in Kern High School District, 65% of students in Kern County, and 54% of students in California. African Americans comprise an additional 5 to 6% of students in each of those education systems. Through the multifaceted settlement before us today, the plaintiffs and the Kern High School District seek to put an end to over-disciplining students and to pushing them out of school, intentionally or unintentionally, and to eliminating resulting gaps in achievement. Under the settlement, in addition to other terms, the district will restructure its discipline system to emphasize early intervention and a robust training schedule for its teachers and staff on implicit bias, racial equity, and related topics. The district has agreed that it will not expel or involuntarily transfer students for willful defiance, and it will ensure that student behavior policies and practices are consistent at all district schools. The district will bolster parent and community engagement. Forms and notices regarding student behavior will be provided in English and in Spanish, and a community forum will be convened twice a year to report on progress made on student discipline and inequities, and to garner feedback from the community. And the district will also make funds available for the parent and student plaintiff to seek reimbursement for lost educational opportunities. The terms of the settlement will be implemented over 3 years. As Cynthia has pointed out, fully realizing this settlement will require the plaintiffs and community members' vigilance and participation. We will do our part to closely monitor progress under the settlement, to hold the district to its promises, and to ensure that this historic settlement is effectuated. Many of the policy reforms in the settlement reflect issues that local advocates, including the plaintiffs in this litigation, have been organizing around for years. And there will be more reforms to advance in the years to come. Community members will have valuable experiences to share and other good ideas for eliminating disparities in discipline and achievement gaps. So we need you to join us at the community forums, and we need you to continue participating at regular district board meetings and LCAT meetings. Thank you.
Our next speaker is the most valuable player on the team for reasons that she can talk about later, Lindsay Andreas of GBLA, which is our host for the event.
Thank you, Eva. As you said, I'm an attorney with Greater Bakersfield Legal Assistance, and GBLA provides services to the low-income community throughout all of Kern County in a number of different areas. I represent students on individual school discipline cases here in Kern County. It was truly an honor to participate in this lawsuit and really bring changes on a wide scale to the students here in Kern County. Some of the changes that were brought about through the settlement agreement that maybe seem smaller but are actually huge in changing the school from a hostile education environment to one that is inclusive to all races and ethnicities. Some of those changes are that the school has agreed that they will immediately notify parents and guardians if a student is taken into custody by a police officer. They have also agreed to provide forms and notices related to the discipline of students in the parent's primary language and provide interpretation at all proceedings and translation of any documents that are given to the parents. They're supposed to provide homework now and allow students to contact their teachers if they're suspended pending their expulsion hearing. They're allowed to have their expulsion hearings in some of these outlying districts that are outlying schools that were hard for them to even find transportation to go advocate for their rights at their expulsion hearing. The district has agreed to arrange the expulsion hearing room in a less formal and more collaborative setting, so it's not like a courtroom atmosphere. They've agreed to make a commitment to recruit and hire a diverse staff and provide reporting every year on the racial and gender makeup of their staff so that the community can know whether they're actually following through on that commitment. They've agreed to recognize Black History Month and National Hispanic Heritage Month and allow students to celebrate those events. As Cynthia mentioned earlier, they've agreed to use a new data tracking system, and that will provide us with better ways of tracking the student behavior and the particular staff responses to that behavior. It will show the race and the gender of the students, and the experts that we have gotten hired by the district, they will have access to that data and be able to follow up and make changes if necessary based on that data. It's extremely important because it will show us whether the district continues to disproportionately discipline African American and Latino students or whether the changes in the settlement agreement are working. As Cynthia also mentioned earlier, this lawsuit was brought by members of the community, and throughout the almost 3 years that we've had this lawsuit ongoing, we've held community meetings throughout the county so that we could receive input on what was actually occurring within the district and so that we could make sure that we address the community's concerns in the lawsuit. As part of the settlement agreement, we felt it was necessary that the district have community forums twice a year so that they report back to the community and can be held accountable, so that the community can bring their concerns to them, so that they can receive information on the data on the school discipline rates, so that they can receive the results from school surveys given to students, and that they can have reports on the training that's being conducted at each of the school sites. These community forums are incredibly important in holding the district accountable and making sure that they really follow through on the agreements that they make. And then lastly, I really want to acknowledge and give a huge thank you to all of our student and parent plaintiffs that participated in this lawsuit. Individuals were truly courageous in coming forward to be a part of this. Many of them feared retaliation or that they would be subject to more hostility at school. These students and parents were traumatized by what they experienced within the district, and they had to revisit a lot of those experiences through this legal process. In bringing this lawsuit, they weren't motivated by self-interest, but by the opportunity to change a discriminatory system. These students and parents wanted to change the system so that future students did not have to experience the same discrimination and denial of rights that they did. We believe the settlement agreement will do that, and that the parents and students should be incredibly proud of that accomplishment. They were brave to stand up for the rights of others and make a difference in their community. And while the parents and student plaintiffs did not expect to receive anything other than changes to the district, the settlement does provide for some educational remediation funds for each of the students. And these funds will help the students get back on track and allow them a better opportunity to pursue their dreams. So we're just really grateful that they came forward and were willing to stand up for others. So.
I'm Eva Patterson. I'm president and co-founder of the Equal Justice Society. We were formed in the year 2000 because the federal court started moving in a very conservative, anti-people of color direction, and we also felt that people were not talking candidly about race. Our motto is, we're transforming the nation's consciousness on race through law, social science, and the arts. We follow in the footsteps of the people who brought the case Brown versus Board of Education, which started to desegregate our nation's schools in the middle part of the last century. The lawyers in that case used social science concepts to convince the court that racial segregation was very negative for people of color and for white people as well. All parents want their kids to get a really good education, It opens doors for their kids, and it enables them to get better jobs, it enables them to think critically. Black and Latino parents, and my mother always told me this, she said, get an education, they can't take the education away from you. And the notion was that no matter how much racism you encountered, if you had a good education, you could have doors open and move ahead in society. Unfortunately, suspensions and expulsions of Black and Latino kids have prevented our children from getting those excellent educations. A statistic that we found that still bothers me to this day is that if you're a Black child in Kern High School District, your chance of getting suspended is 500% higher than if you're white. If you're Latino, it's about 400% higher than if you're white. And the problem with that is that often a white kid will be doing something and nothing will happen to them, but a Black and Latino child will be doing the same thing and that kid will be suspended or expelled. We are very engaged in social science at the Equal Justice Society, and we found that missing even one day of school very much diminishes your opportunity to graduate from high school. So if you're suspended or expelled, you're in a world of trouble. We all know about the school to prison pipeline. The most important statistic about people in prison is that they're not well educated. So if our kids are not getting the education, they're being dismissed and just disregarded by the district. Now, we know that most teachers do not want to be biased. Most people do not want to be biased. But what we have found through our social science research is this. Most of us have unconscious biases. We have stereotypes that we hold, and Black and Latino people have these biases as well. But we have stereotypes that we hold about Latino and African American people. We are seen as violent, as aggressive, as not really caring about education. Many of these views are not held in the conscious mind, but are held in the unconscious. Other concepts such as racial anxiety also lead to the disproportionate expulsion and suspension of kids of color. If you are the only Black person or Latino in a predominantly white group, your cortisol level goes up, your stress level goes up, and your cognitive ability or your ability to make good judgment goes down. Similarly, if you're the only white person and all the people around you are Latino or Black, your racial anxiety goes up, your stress goes up, your good decision making goes down. What we have found is that these concepts are part of why so many of our kids are being suspended and expelled. So a groundbreaking part of our settlement is that we're having, as my other colleagues have talked about, experts from around the country come in to help the teachers, police, campus police, bus drivers, people in the cafeteria. It's not just the teachers, it's the whole system of people who think our kids are dangerous. These experts are going to come in and do some training. If any of you have been involved in psychological work, you know that the first step towards changing yourself is awareness. So we want the district to be aware of the fact that these unconscious biases, these misuse of stereotypes, these racial anxieties result in our kids being kicked out of school. There are other ways to manage the classroom. You don't have to suspend or expel kids in order to manage the classroom. Some of the kids are coming from very difficult situations at home and they're acting out in the classroom, and kicking them out of school is the very worst thing that you can do for them. So the experts coming in are going to help the teachers understand why they may be suspending and expelling our kids, why they may be afraid of our kids and aren't really aware of this, why they may be treating Latino and African American kids different than they treat white kids. There are things such as restorative justice that can be used in order to deal with a child who may be acting out in class. So basically we want to keep our kids in the classroom so they'll learn, so they can be like us and have good educations and have good jobs and not be put in the school to prison pipeline. We want to make sure that we have a system where parents and kids can realize their dream of a better education. And we think this settlement will have a great deal to do with having that result. So we're just beyond thrilled. You have no idea how excited all of us are about this, and we think the district is going to be transformed, and we're going to be watching, and we'll be back if they don't live up to the settlement.
That's right.
There you go. Thank you. In civil rights history, there often have been churches and temples and imams and mosques who have been involved in the push for justice. It's all part of the compassion that's part of most spiritual traditions in our world. And we've been honored to represent Faith in Kern, and our next speaker is Joey Williams from Faith in Kern.
Thank you, Eva. Thank you to the legal team, to everyone who played a role in this. And I know Lindsay played a huge role in this, but I just want to give a shout out to the real MVPs, which is you all, who have been on the grind at school board meetings, who have been showing up, holding the district accountable, who have been a part of this whole process. So please give yourselves a round of applause. All the plans, all the other partner organizations, the folks who do day-to-day work on this in our Kern Educational Justice Collaborative, through the BHC, to all of our partners. And I want to give a special thanks to our Faith. We are Faith in Kern now, but we're formerly Faith in Action when we entered this lawsuit. But I really want to thank our board of directors, because when I came on, I had just inherited this lawsuit. And when they told me that my board, who I used to sit on, voted unanimously to go on this, I was like, our board? It was a great step. It was obviously the right step, and I'm glad that they did that. So I want to give a shout out to the Faith in Action Kern County Board, which is now a part of Faith in Kern, and Faith in the Valley, with the people network. I believe that we're all here for a reason, is that we have a bold vision for our children to have access to a good education, good jobs, and an unlimited future. Many of that has been overshadowed with assertions that this lawsuit is costing a lot of money, that it's being wasted. But it's really not about that. It's really about the future of our children. There is no price tag we can put on the education empowerment of our young people. This lawsuit was personal for me. I have fought this insidious school to pipeline that Eva referred to, that tracks our black and brown students to prison, since I was expelled at 15 years old at Highland High School under zero tolerance. The Kern High School District wrote me off many years ago, but God always has the final word. I'm a university graduate with a master's, and I'm also director of Faith in Kern, as mentioned, which is a growing multiracial, multi-faith network putting racial equity at the forefront of everything that we do. No kid should ever be thrown away, counted out, and no child is expendable. This fight is not over, my friends. It has only really just begun. We need to continue to watch, pray, and provide oversight to a district that has failed our sons and daughters for decades. We need to fight and ensure that they have a quality education, restorative justice practices, and true investment to move into the workforce and to universities. Faith in Kern is eager. I know Rachel Godsill personally. I've worked with her with our PICO network. We're eager to work with Rachel Godsill, Dr. Godsill as we now dubbed her, and Dr. Sprague to ensure our children have the best education possible and that positive behavior intervention and supports and restorative justice is fully implemented. We will keep vigilant watch over the Kern High School District and make sure that these several agreements are kept and that our students get the education, life, and future God intended, not one dictated by incarceration, divestment, and extraction. Please join Faith in Kern and our partners in our organizing efforts. We got a lot of work to do to implement this bold vision. We have the deadliest police forces in the United States. We have the school to prison pipeline. We have a California Department of Justice investigation in the multi places. And we also, for the first time, have a contested DA's race in 35 years. For us to really do this well, we have to dismantle every piece of this insidious pipeline, piece by piece, and implement a school to prosperity, a school to jobs and university pipeline for our children and for our future. Thank you, and God bless you.
One of the most exciting parts of this litigation is representing a living legend, Dolores Huerta. So she's going to come and talk, and after that, I'm going to turn the baton over to Cynthia to field questions and answers. So without further ado, Ms. Dolores Huerta.
Thanks very much. Put the mics down a little bit. There we go. Okay. Well, I just want to say this is a big victory School District. Sir. Over here, town 23. Stand up. Yeah, I need a little, the Barbara Boxer bench, you know, on my chair, yeah. Anyway. No. Let me take the mic, you know, just go over to the side.
There you go.
Okay, well, this is a major victory for the parents and the students of the Kern High School District who organized, started 3 years ago, and we were able to find out what was going on in the Kern High School District. And we are so grateful to these wonderful, incredible attorneys. Please give them another hand, okay? All of we are grateful to the Kern Education Justice Coalition, which is an organization that was formed of all these different organizations that care about the education of our children here in Kern County. And I also wanted to give a really big, and please give them applause to the California Endowment, who made it possible for our organizing efforts and it is unfortunate that the Kern High School District decided to fight this instead of knowing what the statistics were. I mean, the evidence was all over the place. You know, we had many press conferences and meetings with the district, and they were very recalcitrant. And unfortunately, the money that they spent on this lawsuit could have been used for other good issues there in the Kern High School District. Nevertheless, we see this as a very big step forward, but we do want to assure the parents and everybody else that we are going to continue to be involved. We want to make sure that the monies that they get for the low-income students, the English learners, and the foster children, that money is spent where it's supposed to be spent. So I can assure you that our parents will be present, continually present, and not only that, we're going to continue in many other school districts. Right now we're involved in 7 school districts to make sure that the money is spent appropriately, the way that the legislature dictated that it should be spent. The other thing is that this is a big message for all of the Central Valley. 40% of the school districts that have the highest suspension rates of Latino African American students, and guess where? In the 40% of all the school districts in the state of California are in the Central Valley. So what we see here in Kern County is happening in other parts of the state, especially in the Central Valley, where we had high numbers of Latino and African American students. So we're going to continue the work, and I'm sure we'll be partnering up with these attorneys again, but hopefully that this will be a big lesson that the other school districts can learn from, and that they will actually start doing the right thing when it comes to the student population. You know, the one thing I have to say, Kern County is known, we're #1 in sports, right? We're #1 in country music. But you know, 80% of the students that go to community college need remedial courses. What does that mean? We have to be #1 in academics. We can no longer be counted as a deliberate We have a very strong team that is completely committed to make our education better in this county, and we're going to continue working, and hopefully, with additional resources, we can spread throughout the Central Valley. ¡Sí se puede!
So we'll take questions from me in just a minute, but I just wanted to remind everyone once again of how grateful this county and the students in Kern High School District have to be to Arlene Sanders, Ruby Watson, Patricia Crawford, Keschel Collins, Katina Franks, Mario Ramirez, Juan Moran, Virginia Melchor, Marbella Ojeda, Maria Gallardo, Isidro Larralde, Gabriel Elder, Carmen Ramirez, Catherine Robles, Robert Robles, our taxpayer plaintiff who said, you can't use my tax money to do this to kids. Laura De Leon. Dolores Huerta Foundation, the National Brotherhood Association, who's represented here by David Williams. So if there are questions, we'll field some questions, and I will, if you have a specific question for a specific speaker, let us know. Otherwise, we'll take them as we see them.
I have a question en español. Dolores, ¿qué significa esta demanda para los estudiantes hispanos y afroamericanos aquí en el condado de Kern? ¿Y puedes acercar el micrófono del 17 un poquito más hacia ti? El azul. El telemundo.
Bueno, primeramente van a ser cambios que se están comprometiendo en esta demanda que hicimos en contra del distrito escolar de la preparatoria de Kern High. Y se me hace que nosotros vamos a estar vigilantes para asegurar que estos cambios que dicen que lo van a hacer, que en realidad sí los van a hacer. Así es que siempre necesitamos el apoyo de los padres y los estudiantes para que se comuniquen con nosotros para asegurar que estos cambios sí se van a hacer. Pero lo que esperamos es que los niños, los estudiantes aquí de Kern High School District, de la preparatoria, van a tener una mejor educación, van a estar protegidos, que no se pueden sorprender o expulsar de las escuelas. Para nosotros es una victoria muy grande, pero especialmente para aquellos padres que se organizaron para llegar a ese momento.
Gracias.
My name is Pinky Guman, and I had a question about the public forums and accessibility. I've noticed that a lot of the city, council members, the meetings are sometimes at 10 a.m. or in the middle of the afternoon, and that's pretty inaccessible to parents who are working or kids. Some meetings that Congress members from other regions hold their meetings in inaccessible areas where it is hard to reach. Is there going to be an effort to make sure the public forums are basically at a time that's accessible and a location that's accessible for the general public?
That is an excellent question, and as you know, the Kern High School District is huge. And one of the specific provisions in the settlement agreement with respect to the community forum is that they will be broadcast at school sites, remote school sites, so that parents can access them there and provide questions and answers there. Greater Bakersfield Legal Assistance will meet with the representatives from the school district prior to the forum to work out those timing issues. We agree with you, it's really important that those forums be set up at a time when parents and students can actively be engaged in and participate, both to receive information and to provide information to the district. It's a really good question and something that was of great importance to us during the settlement negotiations. Thank you.
Dr. Tatum, Change Community. Recently, they were trying to have a proposal to bring weapons on campus for the teachers to have weapons. Are you guys aware of that?
The Dolores Huerta Foundation, that is one of our issues that we are fighting, and we're going to continue. We've already submitted a couple of thousand signatures, petitions to the school district. Oh. Yeah, the guns in the schools issue is one that the Dolores Huerta Foundation is fighting. Thank you for the question. The Dolores Huerta Foundation, this is one of the issues that we are fighting, to take the guns out of the schools. We've already submitted over 2,000 signatures to the Kern High School District. We have attended the Kern High School District public meetings, and it was very interesting because when they had those hearings, most of the people that testified were against having guns in the school. And unfortunately, Chad Vega, the previous chair of the board, made that his last vote before he stepped off the board because he knew he couldn't win re-election anyway. So it's tough. It's an issue. Of course, we want the community to support us on that issue because we know if they're going to do it here in Kern County, they're going to go to the Central Valley and they're going to try to do the same thing. So I think it's inherent upon all of us that we make sure that we get the guns out of the schools because we do not want to put our students in jeopardy. Eva Patterson mentioned earlier about the stress level of students of what they feel when they're in a classroom. Can you imagine how that stress level is escalated when you know your teacher might have a gun, okay? And we have had issues where students have been tased, where children had their fingers broken in this Kern High School District, and other types of assaults that students suffered. And we just don't want to see the day when a student is shot, or maybe a gun misfires, or a teacher is shot. We can't face that day. So we've got to continue to work on that issue. Thank you.
That's something I want to add on that. Just going back to what you said initially earlier, that meeting to pass that resolution was held at 2 p.m. on a Thursday, when most parents couldn't. And that's been the argument, not only that, for these wide meetings that we're going to be having, is how do we make sure that they have the languages for the Spanish speakers and other Punjabi speakers that for the meetings, and that there's a proper networking and outreach for those meetings. Right? Not just the internet. They said they would post things on the internet, but a lot of our families don't have internet access to get on their website. So how are they effectively knocking on doors, making calls, sending flyers home with the students to make sure that those meetings are public? And organizations like ourselves will be at the forefront of making sure we get our parents there. Going back to the guns issue too, is that we've met with Jeff Flores, and we're meeting with Joey O'Connell soon with Faith and Kern. So please get a hold of us at the press conference. We'd love to have you in those meetings to have those discussions with our elected members.
I just wanted to add one more thing on the gun issue. There is actually state legislation pending right now, AB 424, that would eliminate guns in schools. So at least the state legislature has responded. So.
From Radio Bilingüe. I would like that you elaborate a little bit more about this team, the group that's going to be formed to advise or train the district about the new behavior. Because right now I was checking the Kern County School District webpage, and they are still saying that this is a financial settlement. They are not recognizing anything. How they're going to be act? It's going to be for and their timeline.
Currently, the district has retained John Eiler and his institute to work on issues related to discipline, positive behavioral, instructional supports, and also retain the services of an excellent expert, Dr. Eddie Fergus, out of New York, on the issues of racial equity. What we found during the course of our litigation is that Dr. Fergus is not local and had limited access to the development of the discipline materials, and so his racial equity issues were kind of addressed on the side. In addition to that two-team, the settlement agreement brings two experts who are retained by plaintiffs early on, who actually consulted with Dr. Eiler and Dr. Fergus, provided them with input, helped them develop the training schedule, helped them develop a schedule of reflection and evaluation of the progress of implementation of the training schedule, and will inform the development of the behavior matrix and what's called the MTSS guidebook, the guidebook that's designed to address how to effectively intervene with behavior problems. They will have a system over the course of the 3 years of the settlement agreement with mandatory meetings and evaluations of the progress, as well as development of the policy changes that Lindsay mentioned in her remarks. This is a huge difference, and in fact, it is a difference between a blast email that includes training opportunities that teachers may take to a system under the settlement agreement where each training will have been informed by these 4 experts, be consistent with their long-term plan for systemic and meaningful change, and then will be evaluated. And as I said earlier, every teacher, every administrator, and every security guard and police personnel, as well as other staff, will have to complete the training in 3 years. That is the huge difference. We asked for it 3 years ago. They wouldn't give it to us. We asked for it at every stage of this settlement of the settlement negotiations in this lawsuit. They wouldn't give it to us. Now we have it, and we can track whether or not the teachers are getting trained, whether or not the policies are being changed, and importantly, whether that's having the desired effect.
Cynthia, 2 questions. Number 1, why do you think that Kern High School District had this policy in place? Do you think the district was intentionally discriminating against Black and Latino students?
I'm going to let Eva answer that.
Oh dear. Okay, I can either BS you or I'll be real, so I'll be real.
Yeah.
I think that most of the teachers and people in the district are not racist. I think they get scared of Latino or Black kids, and just like many people in society do. But we've heard some pretty terrible stories about some things that have been done to our children. So I think there are some people in the district who do think that African American and Latino people are inferior. I think they are the minority of the people in the district, but we'd be big liars if we stood up here and said everybody here is into we shall overcome. I think there's some people who have some real profound racial problems, but I think the majority of the people are people of goodwill, and I think I hope that the training and getting them enlightened about why they may be afraid of Latino and African American kids will result in fewer suspensions and expulsions. And as everybody said, this is not the end. If they're still messing up, we'll come back and go back into court. I think Dolores probably has something to say about this.
I just want to add to that actually one of the school board members who is still on the board had said to us in a meeting, you know, the people down there in Arbor and Lamont, you know, they don't really want their kids to go to college. They want their kids to work in the as farm workers, and they want them to work in the oil fields. This is a direct quote from one of the board members. And we did see, you know, in the last couple of years, we had a very high achieving principal who was actually had the highest graduation rates in the county of all of the schools that had the highest number of Latino kids. Jaime Quinones taken out of his position as principal of Miramontes High School, and instead is now teaching adult education to a number of students because he was getting too good of grades for his Latino children, farmer kids. So there is a very strong bias, but I think that this lawsuit is definitely going to make them change that. Yeah.
And Jose, to give you a more direct answer, yes, I do believe that. It was intentionally set up. No condition exists by accident. It's playing out exactly the way it was engineered. We have a school district that's 72% Latino, and the majority of the teachers are not Latino or Black, but white. And we have a police force that's 85% white, and we have a prison guard system where the majority of the prison guards are white. What we have is a modern-day plantation system of new Jim Crow, as Michelle Alexander outlines, and I believe it is intentionally set up that way to make sure that our Black and brown people go to prison and oppose the system, and that and even poor whites as well. So, you know, I want to put that out there too, that poor whites and people of color are in this system, and it's perpetuated through the school district, and this pipeline, all the way to the law enforcement, all the way to the prison system. So yes, I do believe so.
Question number 2 that I didn't get to ask. So the settlement is $600,000 for attorney's fees, correct?
Correct.
And $70,000 for the students, correct? So already there's a lot of comments on social media that the lawyers are getting the lion's share of the money, that it should be going to the students rather than the attorneys. What would you say about that?
What I would say about that is that over the course of the last 3 years, we've had to defend motion after motion after motion brought by Kern High School District seeking to dismiss this case rather than seeking to resolve the problems. And as you can see, the number of people up here in the room, there were times when we had 4 or 5 different pieces of pleading that had to be submitted on the same day, that 1 or more or 4 or more of the individuals sitting at these tables had to prepare. Now, all the while, the district is paying their lawyer, I believe they said on their website, somewhere around $700,000. Right?
Almost 800.
The $600,000 doesn't even pay for the relatively small hourly salaries of the nonprofit lawyers that are sitting in front of you today. The time out we spent representing with honor and happiness the plaintiffs in this case, we couldn't spend representing other people in Kern County who needed help. And so the district needed to pay for that. And they did. If we had gone to court, our estimate is that attorney's fees would have been doubled, or maybe even 2.5 or 3 times the amount that we negotiated for. Attorney's fees were never a huge issue for the district. What was the issue was whether or not they were going to have to report data, whether or not they were going to have to implement change, and whether or not they were going to address issues of racial inequity. That's what we fought for. That's what it took 3 years of attorney time to get, and that's what we got. And in order to sustain our organizations, we're accepting attorney's fees to compensate us for that time.
I also want to add to the fact is that the district got a bargain, because I know on our end on these fees, we should be paying at least double to maybe closer to $2 to $3 million for this. So it's really, and there's also times that we've been going through mediation for a long time. I've been at every mediation from the district to San Jose to Sacramento and every places. And there are times where the district wouldn't have their act together. They wouldn't have documents that we asked for, and they wouldn't have things in place, so we had to carry out another day, an extra day, and things like that. So a lot of that is going to be on their end too, is how they're showing up and how they're doing stuff on their end. And if they're showing up at that lawsuit like that, then we have to look, make sure that they're going to follow through with these agreements as well. So let's please be vigilant over how we implement these agreements. Let's not go home. Let's not go away. There's going to be a hotline number to call. Maybe somebody will mention that towards the end. So thank you.
America became a very rich country because people worked as slaves and did not get paid. Those days are over.
Yes.
If the district lawyer gets paid, we get paid. We're not doing this stuff for free. We should not feel ashamed. We didn't do this for money, but we worked hard. And so the days of slavery and unpaid labor are over. Thank you.
One more note on that: when Congress established the Civil Rights Act, and when the state of California established the Civil Rights Act, they recognized that these cases wouldn't get done, and there would be no disincentive to these practices unless lawyers could get paid. And that's the reason that attorney's fees provisions come with these civil rights lawsuits. Other questions? Thank you all very much. Well, please, I'm sorry. Oh, okay, go ahead. Oh, I'm sorry. All right. Sorry, I got off script there. Anyway, thank you all very much for coming. We are extremely excited about the turnout today, about the support for the settlement agreement. It is a ratification of the work that our plaintiffs and our litigation team have done. As everyone has said, we will be here for the next 3 years, working alongside the community and the people that we represent. And we hope you all will be there with us. We will report back after community sessions. We will provide updates on information, and we will hopefully change Kern High School District in a way that changes Kern County into an equitable place where there isn't a school to nowhere pipeline, there is a school to success pipeline.